versus Pierre Jefferson.
Good morning, Your Honor. Mark Awad on behalf of the defendant, Mr. Pierre Jefferson, is present in court. Standing to my immediate right. Pierre Jefferson. Your Honor, we have had an opportunity to...
Your name, sir?
Pierre Jefferson.
Thank you. Go ahead.
We have had the opportunity, Your Honor, to have the PCC, and we are set to go to exam at the next available date. If I may briefly address bond.
Discovery ready?
Yes, Your Honor. Discovery is complete.
I believe so, Your Honor. There might be some videos outstanding. I will look into that today and get anything turned over as soon as possible.
People have their witnesses available March 5th. Preliminary examination will be set March 5th, 2024, 9 a.m. in person. That will be before Judge Perry.
Thanks,
Your bond, briefly.
Yeah, as to bond, Your Honor, Mr. Jefferson is a lifetime resident of the state of Michigan. I do understand these are capital offenses he's charged with. However, the presumption of innocence must weigh in, and the bond that's currently set is tantamount to remand. He has insufficient funds to come anywhere near.
But it's to CSC first. He could be remanded without bond.
True statement, Your Honor. However,
I know.
However, we're asking the court to lower the bond.
Response from the people.
Your Honor, I'm going to request that bond remain as it is. The accusations in this case are incredibly serious that the defendant was engaging in contact with the victim who was a sex worker and held a knife to her throat while he assaulted her. In addition, I understand he's on pretrial federal release for weapons offenses and fraud and has bench warrants outstanding in the 15th District Court. So I believe bond is appropriate.
He was on federal release when
Your Honor,
these allegations came up?
Your Honor, he was on federal release and he's being...
When these allegations arose?
Yes, Your Honor. When these
Motion for bond reduction denied.
Your Honor, if I may finish, please, briefly, if we may.
Go ahead, so I can just get to what I'm going to.
Part of his release was that he clear up his warrants. He surrendered himself voluntarily on.
He was on
February
pretrial
14th.
release when these allegations came up. They're capital cases, counsel. I don't know what you want me to do. Quite frankly, I think the bond's set too low. Motion for bond reduction denied. Thank you.
Thank you for your consideration, Your Honor.
Don't get smart with me, counsel. That won't work well for you. Court calls the case of the people versus Mary Angelo.
Good morning, Your Honor. Mr. Shemke, appearing on behalf of my client, approach will be standing to my immediate left. Oh, I'm sorry. To my immediate right, Judge.
You've done this before. All right. Your name, ma'am?
Mary Rose Angelo.
Thank you.
Judge, we're here for a PCC. I was just retained on this case. I have made contact with the prosecutor. I'm going to be asking for an adjournment. We're going to waive any time provisions. If possible, Judge, I find this matter potentially, it will not go to a preliminary exam. I'm going to ask for a 30-day adjournment, potentially if the court date would allow, the court would allow March 21st. Possible.
First.
Yes, Judge, and I will not be asking for any other adjournments.
Yes, you will.
I won't, Judge.
No,
I promise.
Yes, you will. Any objection from the people? Probable cause adjourned March 21st, 2024, 9 a.m.
Thank you, Your Honor.
Thank you. Does call the case of the people versus Michael O'Leary.
Morning, Your Honor.
Morning, Your Honor. Michael Vincent on behalf of Michael O'Leary, who is standing to my right.
Yes, he is.
Your Honor, today's date time set for a PCC. We need a date for a preliminary examination.
Discovery complete.
As much as I know, it is.
Your Honor, and Mr. Vincent, you can contact me. We can further discuss if there's anything you think is outstanding.
Oh.
Your Honor, there are a few things we do need to address. First of all, the victim in the case was in possession of defendant's passport. That has now been turned over to Mr. Vincent, so they are in possession of that. I just want to put that on the record. Furthermore, there is quite some concern that there have been attempts to call the victim from jail by Mr. O'Leary. So I wanted to make sure that those are addressed here today.
All right.
And if actually Mr. Vincent and I can approach.
Gonna take him a while, so yeah. Record to reflect, we have a brief bench conference. I'm gonna pass this matter briefly to try to resolve some issues, so we can take it back. Thank you. Court does call the case People versus Sheldon Flumet.
Your Honor, Michael Vincent appearing on behalf of Sheldon Brumet.
All right, what are we doing on this?
Your Honor, we need an adjournment. I just got involved. We just got the police report. I'm lacking a couple of things, mainly the search warrant, I believe that's involved in this case.
All right. Probable cause will be adjourned March 14th. Where's your staff? Here. Will that work? All right. March 14th, 2024, 9 a.m. Bond continued. Court calls the case of the People versus Kevin Shametz. Ms. Hamoud? We're oh, sorry to wake you.
Thank you. Tonight, appearing written on behalf of Mr. Showamesh, who stands to my right. I was in a very enthralling conversation with Ms. Julian. And I apologize for making the court wait.
But go ahead.
Your Honor, today's time and date set for PCC in this matter. Mr. Showamesh would like to waive his right to preliminary exam. I've counseled him on the same, and he's executing the waiver right now.
Sir, is that a correct statement?
Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense is alleged committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 2 with 3 following.
Thank you, Your Honor. As to the complaint, waive formal reading for the record, for the information, Mr. Showamesh stands mute. I ask the court to enter a not guilty plea on his behalf.
Defendant having waived formal reading, standing mute, court will enter not guilty plea as to all counts. Pretrial will be set for
February 29th at 1:30 before Judge Slade Thursday.
February 29, 2024, 1:30, Slay Thursday.
Adjourn that one to the next pretrial date. Okay. And I'll come see you.
Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you for your help.
Don't start talking.
The court was just so fun.
Yeah, it's just a blast. Court calls the case People versus Marvin Holland.
Your Honor, Michael Vincent on behalf of Marvin Holland, who is approaching.
Marvin Holland. Thank you.
Your Honor, we just two.
Hands out of your pockets, please.
This too, we need a set for a prelim exam.
Discovery complete.
I believe so.
People have their witnesses available March 5th. Oh, really? Okay. All right. Yes, we can. Preliminary, any objection to that? Mr. Vincent.
Sorry, I'm sorry. Let's go with March 5th. I apologize. The technical will be back out of town.
So what are we doing?
I'm sorry.
5th? Okay. Preliminary examination, March 5th, 2024. 9 a.m. That is in person before Judge Fresh Hour.
Give me a call. Okay.
Bond on this matter will continue. Thank you. Let's call the case People versus Antoine Brooks.
Good morning, Erica Julian appearing.
Good morning.
Good morning. He's standing to my right. Can you state your name?
Antoine Brooks.
Thank you, Your Honor. We're still in discovery. We're requesting an adjournment.
An adjournment?
Yes, Your Honor, for discovery.
How much time do you need?
I think another 2 weeks. We've requested some body cam and I expect that back anytime.
Probable cause conference without objection will be adjourned to March 7th, 2024, 9 a.m. Bond continued.
Thank you very much, Your Honor.
Court does call the case, People versus Calvin Patterson.
Your Honor, Michael Vincent on behalf of Calvin Patterson. Your Honor, today's date time set for a probable cause conference. We're requesting a prelim exam. If we could bump it, throw it past the March 5th date.
Discovery is complete.
Just yesterday sent over the 911 calls, the CAD notes, the dispatch audio, but I'm realizing I sent that to a person in Mr. Vincent's office that might not be available this week. So I don't know if Mr. Vincent wants to review that first before we set for an exam.
That might be a good idea.
So you'd like an adjournment?
That may be even a better idea.
Probable cause conference will be adjourned to, will the 7th work for him? It's amazing. It's amazing you can't keep your own schedule. March, it's
No comment.
March 7th, 2024, 9 a.m. Bond continued. Here. Court does call the case of the People versus Tracy Vincent. 2 cases. Other side.
Oh, I just, thought you pointed over
No,
there.
I was asking him.
Oh, okay.
Ready, Judge? Oh, no, it's, I'm on.
Prosecutors on Zoom.
I am. Good morning, Your Honor. Chris Fleming, P75946, appearing on behalf of the people, special prosecuting from Lenawee County.
Thank you, sir.
Ready, Judge Torshio Feaster, Assistant Public Defender on behalf of Mr. Tracy Vincent to my right at the podium. Please state your name for the record. Mr. Vincent.
Tracy Alexander Vincent.
Same time set for a PCC in this matter, Judge. I believe this is also a forensic evaluation we're waiting for that has not come back yet. They are trying to restore Mr. Vincent to competency, and I do not have a copy of any update. I don't know if Mr. Fleming had, I do not have.
It looks like the last update we received was from February 5th, indicating the time on 23F55048 has expired, but the time on 23F55044 has not as of yet. So I will leave it into the honor's discretion what we do with the 5048 case. But it looks like we're still waiting for admission on the 5044.
So it seems to me that the best move would be to adjourn both out. Unless
Sounds
there's
good.
an objection.
Sounds good to me, Judge. Mr. Vincent.
Remember we spoke about.
I'm doing it. All right. Mr. Vincent does want me to make a request, Your Honor. Obviously, this matter was referred for competency. Mr. Vincent would like to have a hearing on his competency. Although I do not have any additional information to add, we have not done an independent evaluation, but he would like to have a hearing on that matter if the court would allow. I don't have any
Well,
additional.
we're waiting on one other report.
I understand that, Judge, but he wants me to request a hearing. I told him I would do that, Judge.
Your Honor, under the Michigan law 3302020, a person, a defendant can only be determined incompetent to stand trial if they are incapable of understanding the nature and the object of the proceedings against them. My attorney can tell you that I'm
And
not.
can rationally assist in their defense,
Yeah,
which I don't know.
yeah,
that you're-
exactly.
Which I don't know that you're doing right now, but go ahead.
Sorry, I didn't, but my attorney can tell you that even my attorney, Andrew Banners, back in April last year stated that I was not incompetent to stand trial. Police officers put in the report that I made statements that I was suicidal, that I wanted to get murdered, statements that I didn't make that could be found on the body cameras that I did not make. And it's false statements that was made that committed me to the treatment that I'm being sent to right now, which is illegal. It's also a felony under the Michigan law 750-410A. So I did not make any statements. I understand the nature of the proceedings against me. I understand the charges. I understand the preliminary exam. This is my first time in here. You know what I mean? And I just like to request a hearing to challenge the forensic.
On one of your cases, I don't have a report.
So he has to wait for your report, he's saying, for the second case that has not come back yet.
Right, but they've already said I was incompetent to stand trial, and I've been incompetent the whole time. That's what I'm saying. Now, I've understood the nature of the proceedings the whole time. Even Andrew Banner said it back in April last year, and this is holding me up in violation of my Sixth Amendment right to speak.
Where are you going, Mr. Bannon?
If you can remember.
Obviously, Judge, I'm not a doctor, and either is Mr. Bennett to my knowledge. But I have been able to communicate with Mr. Vincent, but I don't have any additional information to provide. I don't have an independent evaluation. I have nothing to offer in terms of evidence, but he would like to have a hearing on that issue otherwise.
Doesn't make any sense to do one and then the other report because I have no idea what that's going to say.
Understood.
So I'm going to adjourn the competency hearing. I don't have the report. And what I will do, and Mr. Vincent, listen very closely. I guess if you've read the statute, you understand how this works. I'm going to give you a date that's going to be in April. However, if a report comes in before then, it can be set earlier than that. It will be moved up. Understood?
Yes, sir.
I think he has one more request, Judge.
Okay, let me set the date and then I'll deal with the request. Go ahead. The hearings will be set for April 4th, 2024, 9 a.m. What's his other request?
You know, I think he wants to address this bond.
Go ahead. That's worked very well today.
I understand, Judge. He's been incarcerated, I believe, for over 7 months on this matter. 11 months on this matter, Judge. Obviously, he's still pending the forensic evaluation being completed, but he would like the court to consider addressing his bond. I do know his mother is involved in his life. She did come to his last court date to support him. He asked the court to consider a reduction in his bond despite the pending forensic evaluation, Your Honor.
Response from the people.
Judge, these are very serious cases. He has quite an extensive record. People would request bond remain the same.
His bond is set actually at a relatively minimal amount of 5,000 cash surety each case, given the nature of the charges. Motion for bond reduction is denied.
Please, I'm just going to leave it where it is. We'll talk.
Thank you.
Thank you very much, Judge. Appreciate
Bond
it.
will continue.
Thank you, Judge. Have a good rest of the day.
You do the same, sir.
Thank you.
Let's call the case. People versus Benny DeNovi.
Your Honor, good morning. For the record, this is
We
Mark
haven't
Burke.
seen you in a while, Mr. Feaster, and you like got all the cases. Okay, go ahead. Go ahead, Mr. Attorney General.
Thank you, Your Honor. Good morning. For the record, my name is Mark Burke. My P number is 54935 with the Attorney General's Office, appearing for the people.
Ready to get Judge Torshell Feaster, Assistant Public Defender, on behalf of Mr. Benny DeNovi, who is on Zoom. Mr. DeNovi, please state your name for the record.
Benny DeNovi. All right, thank you.
Thank you, Your Honor. My understanding is that Ms. Gaines handled this case last time. Mr. DeNovi did have a motion that was, I believe, filed in the family court. That motion was ruled on in his favor in terms of his child support arrearages, I believe. But there's a window for the other party to appeal that decision.
To object to the recommendation.
Correct. Yes, Judge. So I am asking, or have been told to ask for an adjournment past that window.
It's a 21-day objection period.
Yes, Judge.
And so the ruling came when?
On the 5th, I believe I was told.
I think it was the 6th.
The 6th.
So if I go to March 7th, we should be good.
We should be good.
Any objection from the people?
No objection, Judge. I guess the only question I have for Mr. Feaster is whether or not is there an income withholding order in place right now?
Is there a holding with order?
Income withholding.
I have no idea, to be honest with you.
All right.
Mr.
He
DeNovi
doesn't do family law.
Yeah.
He has no idea.
There was some discussion at the last hearing about defendant's new employment, and there was a payment of $500 made in about 10 days ago or so. But it was not through an income withholding order, so I wasn't sure if there was one in place or not.
I did provide friend of the court with all the information to send the withholding order. I don't know if that's been issued yet. And it may be pending,
Information for an income withholding order? Is that what you said, sir?
yeah, I provided the friend of the court with all of the information for the employer to contact the employer and set up the to provide them with the withholding order, but I don't know.
Okay, if he did that, if that's correct, it's just gonna take some time for that to
Right.
go through and click in.
Okay, no problem.
March
Thank you, Judge.
7th,
March 7th at 9 o'clock.
2024, 9 AM.
You gotta thank you very much.
Bond will continue. Mr. Attorney General, I know it's not intentional on your part, but I don't allow, in your background, you probably didn't notice that I don't allow political signs in the background. So if you could just make sure to rectify that for me.
Yeah, you're talking about the sign with Mike Cox.
Well, thank you for advertising that too. Yes, that's on.
Sorry, Judge.
Thank you, sir.
Sorry, no problem, Judge. Appreciate that.
Court calls the case, People versus Gary Lockwood. Then I'm gonna do them.
Good morning, Your Honor. Marcia Crater on behalf of Mr. Lockwood. If I could have a quick moment, Your Honor. Your Honor, thank you very much. Your Honor, I was just informed today by Madam Prosecutor that there is still some discovery outstanding, and I'll let her put it on the record exactly the issue and the time frame.
That's correct, Your Honor. We did get into defendant's phone after some time. My understanding is that my officer in charge is out of the country this week. We will not be able to get that information until the following week, so 2 weeks from now. So Ms. Crater and I did discuss setting for exam as per her request, and that she probably would get that information for about 2 to 3 weeks.
With that being said, Your Honor, I would like to suggest the following to Madam Prosecutor and to the court. We schedule this for another PCC so we can make sure that discovery is set. Okay. And I don't know if the court wants to deal with the competency issue now or wait till that time.
Finding on competency.
Right.
Correct.
That is correct, Your Honor. I didn't know if the court was in receipt of that report. I believe I sent it to him, but I don't know if you have it.
I have a report from January 16th.
That's correct, Your Honor. We will stipulate to the findings in that report, Your Honor.
Also stipulate.
All right, based upon the review of that report. Court would find that the defendant is competent to stand trial. Specifically, the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. And Ms. Crater, I'll need an order.
I'm sorry, Your Honor.
I'll need you to prepare an order to submit to the court on the finding.
I can do that, Your Honor.
All right. And now you want probable cause adjourned. So,
Well, I know the court likes to ensure before setting a preliminary exam that discovery is completed. So short answer, yes.
all right. And so are we looking at about a 3-week time frame? Well, you were looking at a 2-week time frame, and would a week be enough then for you to review that information, Mr. Crater?
Possibly. I mean, I don't know how big the file is, Your Honor.
And I don't either.
I mean, it could
I
be,
think 3 weeks would be appropriate. We can always
Got it.
stipulate if needed.
yeah.
March 14th, 2024, 9 a.m. bond continued.
Thank you, Your Honor.
Thank you.
Thank you.
Christopher Keith, virtual page.
Is the date and time set for a competency review here? Does the court have an updated review?
I have a report from January. Is that our most updated one?
That should be the most updated one.
No, excuse me.
Yeah.
And they said I was found. Forensic.
Now, we have no further evidence to present. The January should be.
Any other additional evidence from the people?
Thank you.
Based upon a review of that report, the defendant is no longer incompetent to stand trial and specifically understand the proceeding nature and the object of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent.
Thank you, Your Honor. We will prepare orders to that effect. We are respectfully requesting a probable cause conference date at this time. Yes, so we can move forward.
Well,
Set a probable cause. I'll set a probable cause conference for March 7th, 2024, 9 a.m. Bond will continue. Thank you.
Very good.
Court calls the case People versus Ryan Ellis. You know, whenever anything happens like that, Feaster is gone. Feaster, he's like back in the audience playing and everything. He's like, I'm not part of it. then once it's gone, he appears back.
Assistant Public Defender Jay Bellinger on behalf of Mr. Ellis, who appears before you, Your Honor. And Mr. Ellis, can you please state your name for the record?
Ryan Ellis. Okay, good morning. All right, what are we doing?
Your Honor, we were asking for an adjournment until about mid-March. I've talked to Mr. Childers to see how we can progress with this case. He's agreed I can let him address what our plan is if he can do it more eloquently than I can right now.
I'm sure that would happen.
Yeah.
I don't know. I need to know that
That's
right now.
fair.
March 14th,
Thank you.
2024, 9 a.m. bond continued.
Get it.
Thank
All right.
you. Okay, so the People versus, is it Dalen Parkus?
Morgan Barosa on behalf of the people.
And good morning, Your Honor. Andrew Meyer on behalf of Dalen Parkus. Mr. Parkus, could you please state your name for the record?
Dalen Parkus.
Sorry.
Okay.
Your Honor, this is the time and date set for a probable cause conference. We are requesting the court set this for the next available preliminary exam date.
You want to address his violation?
Whichever order the court wants to take it in, I'd be happy to address that first.
Go ahead.
Your Honor, it's my understanding that Mr. Parkus came into custody yesterday evening on a tether violation. The allegation is that he was in the vicinity of the alleged victim's home. I believe currently there's a 2-mile hot zone around that particular location in Jackson. What Mr. Parkus tells me is that he too is a resident of Jackson and had been going to a store that's in that location, which is what caused the tether to go
He was
off.
within 150 feet of the exclusion zone.
Your Honor, that's what he's telling me is that.
Okay, go ahead.
I don't know how accurate these tethers are and how close he was to the alleged victim's home. What Mr. Parkus tells me is if he were to be released, he would return to his aunt's home in Jackson. She lives far enough away that there won't be any further problems with its tether. He is currently employed. Your Honor.
Go ahead.
Okay. He is currently employed at an auto parts manufacturing plant. He's had that job for the last 2 months and he would like to return to it. He also has a 4-month-old daughter who's currently residing with his mother. Mr. Parkus is 19 years old. I know that he wants to bring this case to a resolution as soon as possible. I think his desire here is just to set this for an exam, determine what will happen. I don't think there was any part, at least from what I'm seeing here, any indication that he was intimidating or trying to prevent the alleged victim in this case from coming to court or anything along those lines. So I would ask the court to consider re-releasing him on tether and setting this for an exam.
Response from the people.
I do want to note for the record that an offer for misdemeanors was formally extended for the defendant to plead to counts 2 and 3 as charged. In exchange, count 1 would be dismissed with an agreement to $240 in restitution. So if you wanted to get this case over and done with, we could do that today. If that is not the case, and you want to proceed to exam, we are ready to proceed and we would be happy to set it. I would object to setting his bond back to where it was. It was set at 5,000 cash or surety. We did request 250,000 initially in this case. That is because this occurred at Mott's Children's Hospital, where the child was being treated for non-accidental trauma. CPS is involved in that, but the defendant strangled the victim at Mott's and then stole her phone. When she was trying to get the phone back, he threw it into the sewer. He admitted to taking the phone. The victim had red marks around her neck. And the defendant made statements as to the red marks around the victim's neck, even when officers did not ask any specific questions about that. We are significantly concerned about the nature of the allegations, about the fact that he was so close to the victim's proximity, despite having a GPS tether on. We also do want to note that the victim reports that the defendant, this was not the first incident of an assault between the defendant and the victim. In her words, she said the defendant assaulted her many times in the past, including times where, as a result of the assault, she became lightheaded. This appears to be a very high lethality situation. I understand that the defendant is young, but this is a strangulation, and it occurred in a place that is very public. So that does not appear to be any type of inhibiting consideration for the defendant either. So we do not believe that he is safe to be out of custody.
Anything else, Mr. Mayor?
Your Honor, all we have is this tether violation. If there was more, I think the state's concerns would be founded, but I think all we have is that he's somewhere in the proximity, which he could have been for any number of reasons.
Well, except for the fact that he was released on that tether around mid-December. And you're right, we don't have anything else, which is why I don't believe his story that he's all of a sudden in the proximity of a store that he regularly goes to, because that would have happened well before now. Is all of the discovery complete?
I believe so, yes, Your Honor.
Discovery is complete and witnesses would be available on the 5th.
Yes, Your Honor.
So the first thing I'll do is I'll set the preliminary examination March 5th, 2024, 9 a.m. That would be before Judge Perry. And at this time, given the bond violation, defendant's bond will be revoked pending that hearing. Thank you.